Okay, abusia yɛbɛma makwaba sonko so ɛdeba ɛyɛ Ghana Politics Avenue so. Abusia yɛmbonra ɛyɛ yɛnsɛm mu. Ɛna no ada yɛde Kpandai ho latest update ɛde ɛbrɛ mu. Ɛyɛ Supreme Court kwahye a ɔkwahye ɛyɛ rerun of elections na ɛba bɛba so. NPP&EC legal team ɛkyerɛ sɛ ɔmo pɛ sɛ ɔmo file for review na Supreme Court ne ruling ne deɛ ɔmo ne omo enyadwe and Matthew Nyandama court ebabe punish no over say why they wa mislead the court no ehun sensem na ene Dr. Rashid Tanko de nsem bi ababe to dwa ne nsem odi ababe to dwa no abusua some crooked gazetted document bi a NPP any electoral commission ekabo ma omo de ebri court ne so abusua NDC deputy director of election Dr. Rashid Tanko ababontin ababe expose wa drop sa document no de ama judges na abusuya enye asem ketwa kra o kire say sa gazetted document NPP fo nya sa gazetted document no on the 6th of January enke any kwan say e happen into no obisa say sa gazetted document ya NPP fo no omunya free hefa electoral commission at the moment, and as a half opportunity if say any omone electoral commission and a boom and a omopese omorege Kpandai elections now. Now that means say gazetted documents no 6 January now omunya sa document no a half an omokunya abusia intino nasma o kan ocha or say EC any NPP sa crooked gazetted documents no abusia NEC and the ma NPP for no intino omo wo leaky sa document no ama judges for no e de omo mo me yakọ na yakọ kuti ensema Dr. Rashid Tanko e de etuja unsubscribe here subscribe like na share ma afofron so ensa into me and kebi and don't forget to click on the notification bell so na be any updates be ever dropping on so onsa ebi to me aka
now what do you make of this? This is a point you concede and you can't do anything about because the facts are against you.
You see, Counsel, my sister has made our work easier. I told you that we have filed in our affidavit in opposition to the application at the Supreme Court. We were citing them for fraud. The Electoral Commission and the NPP. She has made our work easier. And I'm very happy with her presentation on the element of fraud.
Too late.
Not too late. We are taking that leg. In fact, we are advising our candidate to take that matter up with the CID, to go into the matter of fraud. Look, perjury is a serious matter. They filed on the 6th of January, 2025, a motion with a supplementary affidavit on 21st January and attach this 6th January Gazette that my sister is trying to run away from. It is the NPP that brought the 6th January Gazette and swore an affidavit that this Gazette was a proper Gazette of the 2024 7th January election. And in that Gazette that they filed at the Tamale High Court included Kpandai. I have it. I can give all their dissent. In fact, their motion, their supplementary affidavit, and then the exhibit of the 6th January. They did it. They swore an affidavit. And you know, when you swear an affidavit and you lie before a court, it's perjury. And these people are otherwise, this thing that is happening, Counsel, we have to take it seriously. Because false representation.
When they filed, they didn't ask you guys to withdraw.
No,
they didn't wait for the court to rule and say, in fact, what they filed was accurate. You decided that, oh, what you have seen looks like that's the correct thing. So you withdrew.
You see, when we filed on 23rd, at that time, Electoral Commission was flip-busting. They didn't want to come out. We know we're forcing them because we conducted the election on the 7th. Up to 20th, and you are not gazetted. 21st, there was no gazette. 22nd, there was no gazette. I would say, what is happening to this EC? We have to go to court and force them out from their slumber. So that was the reason why we filed on the 23rd. So what we filed on the 23rd, quickly, you know that this electoral commission, I always describe it as crooked electoral commission. Quickly, NPP got hold of a gazette dating 6th January 2025. Where did they get it from? Where did they procure that gazette? That is a question we are going to go in. That is the root cause of the fraud that we are talking of. They fraudulently procured this gazette, attach it to their motion and affidavit, trying to get the judge to dismiss our application.
If you have a document,
yes,
and you believe in that document,
yes,
at the time you had it,
yes,
that will not be fraud.
That is why I'm saying that. But when it turned out that the document was procured fraudulently, that is the element of fraud will arise.
The document that you then relied
on, because the EC themselves was a party to the matter. The EC was silent about the issue. When we withdrew the matter and filed on 25th, because we believe them.
But the substantive point is that,
yes,
in the end, you concede that you were completely out of time in filing and also paying for security for cost. And the law is plain that there will not be extension if you miss the time. So, as the evidence go by the Gazette notification that we have seen, which is the only one available, which the Supreme Court has relied on once and then again the second time, you got it wrong.
No, Council, you see, what happened was this. The 23rd one, of which they came on the 6th January to file. I'm talking of their motion that they filed in dismissing our 2013 was filed on the 6th January. Interestingly enough, the gazette that they used was also on 6th January. So where did they get it? The coincidence was so clear. They filed on
you have canvassed that point.
So I'm saying that, yes, we agreed that our 23rd had a problem. So we withdrew that one. And there was a cost against 7,000. So we had to pay for withdrawing that matter. So when we filed the 25th one, then 27, we paid the cost, the necessary, this is based on Section 18 of
those two instances.
Yes.
Those two instances, you were out of time.
We are not out because we're relying on the 6th January Gazette, which they brought and the court accepted it. And based on that, we filed. So we're within 19 days. That was our point. But because we based on what they had filed before the court.
Right. So my last question I put to you is based on the Gazette that we are now using. You admit that you got it wrong.
No, you see, we are still not agreeing because that is why we are citing the EC. Why would the EC come out with two gazettes? Because they, according to the NPP, when they brought it, they said they got the gazette from the Electoral Commission.
The EC says there's always been one gazette.
So they must come and answer the question before the CID.
Okay.
Because that one.
So you agree that this Supreme Court panel, they had no option on the basis of these facts to hold the way they held, correct?
That is why we want to wait on the 6th of February to see the reasoning behind it. And then because in open court, lead counsel for the applicant, my good friend Gary Nimako, when he made his submission and sat down, the president of the panel asked him question on the issue of the fraud. The first interested party raised issue of fraud about that matter. Why is it that he didn't address the court about the issue of the fraud they raised in the affidavit? And I'm happy my sister added to that. He rose up and said it was a genuine mistake. How can this be a mistake? When you make false representation before a court, expecting to get a ruling out of it, and then the ruling went against you subsequently because one went to case management and all that, at the Supreme Court, you now say it's a genuine mistake.
Right.
So that matter must be looked at critically.
Let's proceed, but you would recognize that.
Well, let me say good morning to you and then my co-panelists and the cherished viewers across the globe. Counsel, we accept the decision of the Supreme Court. We are a law-abiding political party, but we disagree with the ruling. We disagree with the ruling totally. Total disagree. And we are waiting for the reasoning behind of their ruling on the 6th of February. They indicated it to come out on the 6th of February. Then we advise ourselves appropriately. Because if you look at, let's set the business straightforward. The Supreme Court doesn't have jurisdiction over the substance of the matter. if you look at the Enabling Act, the P&EC law 284, that talks of election petition. Under Article 99(1) of the Constitution, it is only the High Court that goes into election petition matter. Supreme Court doesn't deal with that.
Supreme Court is a supervisor of the realm.
But it doesn't go into the...
If something goes to the High Court or any other court, the Supreme Court has power to review it.
We agreed. But we are saying that when it comes to the substance of the matter, going to the nitty-gritty of election petition, under Article 99(1), it is the High Court. That one there is I defer that one to you. Now, when you look at the matter critically, what the Supreme Court did was based on technical issue of Gazette, not the substance in itself. If you go and look at the ruling of the High Court, page 151, it's very clear that the election was properly rigged. The judge makes references to those things. And I have the ruling, I can make it available for you, for them to tease at that portion where the judge, the learned judge, mention of a polling station recording 1,422 votes. Council, you know that we don't have a polling station like that in Ghana. That has a voter population up to 1,000. The highest we have is 750. 750. If you have more than 750, it will split into two. But this is a kind of voting that occurred in Kpandai constituency. Now, why are we battling the issue with Gazette? And that is
so. For the Gazette, you mentioned the matter of, is it overvoting?
That is what is pointing out.
Okay, that there is a polling station.
A polling station.
Which has less than 1,000, but there was recorded over 1,000 votes.
1,000, yes.
That's, what do you make of what Dr. Osankwaphong says? In that case, hold that the elections have been, damaged in this particular place. So go and correct it, rather than say go and do a whole new election.
That was not the only one. Don't forget, Honorable Nyindam won about 3,000 votes. In two polling stations, another polling station recorded 1,200 votes. So that means in two polling stations, you have scored almost 2,000 votes. So what are you talking about?
So impeach those two.
So we are saying that is why the judge was looking at it. And we said that when we sent our reliefs to the High Court, we sent 14 reliefs. And then at the case management, this 14 was consolidated, set out for trial. 3 issues were set down for trial. And one of them was we were asking for the nullification of the entire results because of the infraction of Regulation 37 and 39 of CI 127 by the electoral officer and the presiding officer, the returning officer of the constituency. We gave copious evidence and tendered evidence to show that they violated these enabling 2 regulations of the CI 127. And we convinced the judge to believe that, yes, they didn't do the right thing. They violated those 2 regulations. And those 2 regulations borders on the collation of results of parliamentary election. And it was very clear about it. And so when we did all this cross-examination with them in order to, the ruling came out on 24th November. And it was very clear. I am not surprised my colleagues' opponents ran to the Supreme Court because they know if they had gone through the process of appeal, going to appeal court, they were going to suffer another defeat over there. Because I don't know what kind of new evidence they were going to adduce based on what we had cross-examined them and the electoral officer. So they decided to go on this tangent, of which we are saying we will go into it. And when we file our affidavit in opposition to their application at the Supreme Court, we're citing them for fraud, the 2 of them. And I'll give you the elements of fraud that we are going to pursue on that.
But you know that in your main petition in the Tamale High Court, you were clear about a particular number of polling stations that have been affected, correct?
I said we have set out 14
I understand
and one of the lists was what you are talking about.
I understand that.
About the number of polling stations.
How many of them?
We had set out about 51 of them.
41.
No, 41 of them, the polling stations.
Right.
Indicating that they should look at this 41. Because we're making reference to the Regulation 37 and 39 of
so the judge was faulted by many members of the public, including some lawyers, that what was before you was to determine 41 polling stations where the voting was allegedly rigged.
Council,
so why do you come to a conclusion by saying that let's go have a rerun. I've annulled the whole thing. Go have a rerun in the whole constituency.
Council, at case management, these 14 reliefs, when we consolidated it into the 3 issues set down for trial, one of the reliefs among the 3 was the nullification of the entire results of the 152 based on the infractions therein. So it wasn't that we were asking the judge to look at only the 41, but we're asking for the judge, which is the 3rd issues set down for trial. The last one, in fact, I wanted to read that one, the 3 issues for trial.
All right.
And the last one was...
You're going to the merits already.
Yes, and that's why I said. So it wasn't only that we were going in for only the 41, but we were also asking the judge to nullify the entire thing because it violating Regulation 37 and 39 of CI 127.
Yeah, right. There was a relief like that.
On that.
Now let me go to Dr. Arthur Kennedy. Just brief preliminary commentary on the decision of the Supreme Court, particularly also looking at the posture of the politicians and their commentaries when decisions don't go in their favor. Some of the judges, they actually pinpoint them, name them, and try to, as it were, pit them against the public. So as you can see, I had mentioned in the removal process, some of the judges sitting in the removal process, at least one is here. And then the removal process, the issues that have gone to court. Some of the judges who have also, dismissed some applications by, in the process are also here. And somehow, all those people have held for the Matunyindam. Of course, with the exception of Justice Pwaman, who dissents. And we should get to know his reasons why he dissents.
Good morning to your distinguished panel and to all your viewers. I think that this case, it is not the details that matter with respect to my learned colleagues, even though I'm not a lawyer, I'll call them that. I think that it is the broader context. And Dr. Sekwapon begins to tease out some of them. I mean, these Afrobarometer surveys and the mistrust of the courts and others didn't occur in a vacuum. And it is not just the courts. There is a perception that our institutions, including the police and others, are very political, and that when you are in power, it seems that a lot more things seem to go your way. I think that what happened, the thing that gladdens my heart is that it is a victory for the courts, to the extent that the NDC said there is a need to rebalance the courts or reset the posture of the court. I think this shows that maybe tentatively we are heading in the right direction, because something the history.
But the judges who sat on this, who was appointed by the current regime, I need to check again. They are all from the Akufo-Addo appointments.
Yeah, my point though is that that is why I say we should say that cautiously, because this decision in effect telegraphs the independence of the courts, contrary to the anxieties that a lot of people expressed. Of course, politicians are opportunistic, that when things don't go their way, they call the court names. When things go their way, then they praise the courts. But to be fair to them, the history of our courts have not been good in terms of electioneering ruling, that almost invariably those in power tend to get more favorable rulings. So the doubts that people have, the doubts that the public has some grounding, and even when we can go all the way back, but I don't think we have time, even in the Fourth Republic. Remember the Amu case, 1996 to 2000, when Amo lost a case. I think that Ayawa Wugon or something like that, and took it to court, and the case took 4 years, and then just before the term ended, the court came back to say that he had won. I mean, such things are blatantly political, and not only that, which is why I said this is not just about the courts. If you recall, there were a number of constituencies that were in dispute just after this election, and there was the question of whether the police could provide security for the counting and other things. It may have been that the excuses were genuine, but a lot of people saw through it and were suspecting that maybe the political winds were beginning to blow in the ranks of the police. So I think that this decision, I think the details are being argued there by the lawyers very well. But I think to Dr. Saikwapon's point, the anxieties of the public and their mistrust have grounding, and particularly if the NPP people are going to be honest, when you look at the kind of things that happened in the last 8 years and how the Supreme Court seemed to respond to certain people's concerns with alacrity. We empanel cases in the morning and hear things the same day, and then other people's cases languish for months. It is very difficult to look at those things and not be convinced that there might have been some element of bias. But I think we should praise the court that what has happened is a good augury for the future, and I hope that it can continue for the sake of the independence of our judiciary.
NDC Deputy Director of Elections, and Yetsenekan, Dr. Rashid Tanku, Ono, and HSNA or this and Semno Etuja Ediamaya or Chese, Mami, James and any East in Kofono, Omuna you crooked. Omone NPP, and Kabuma, Omopese, Omutun Futru, Edigu, a year. Court any assisiano wa expose leaky evidence or no nonsense more can in fact. Abusia, a better massive some Japanese in some way at the MI. Ghana Politics Avenue. So, and don't forget to click on the notification bells and any updates be able dropping on so once a bit to me.